closing your eyes now, but I know there's always a way. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything much smoother again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. The connections might be tangled, the power source has lost its spark, but every wire tells a story, and I can mend what's torn apart. From sunrise till dawn, I'll be here waiting. From sunrise till dawn, I'll never stop. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. When the current isn't flowing, when the signals disappear, I'll be here with tools and patience, make the static crystal clear. Every cable, every circuit, every problem that you bring, I'll restore what time has broken, make the whole world sing. So don't you worry about tomorrow, don't you stress about today. I've got maintenance for your troubles, and I'll chase them all away. I'll fix you up, make everything run smooth again. I'll fix you up, from sunrise till dawn, my friend. I'll fix you up, with these hands and heart so true. I'll fix you up, Daniel, I'll fix you up. Hey, Daniel, everything's good as new. Hey, Daniel, I'll fix you up for you.
Well, welcome. Welcome to the show. I am your gracious host, Daniel, and today is our Judge Simpson docket. One of my favorite judges of all time is Judge Simpson. And this is a reminder to everybody, tomorrow I am not doing a court live stream. I'm taking the day off, but the scanner feed will be up at night. So I will schedule a scanner feed for that in the evening. It should be pretty interesting. But let's go ahead and get started with our Judge Simpson docket. And make this bigger. And of course, I'm going to be watching and skipping ads where I need to skip ads because it actually gets you copyright struck. But I'm here, so let's get started.
She's taking accountability for the bond violation, Your Honor, and she's asking that the court release her today.
Half accountability. Court calls the case, People versus Deanna Conrad.
Conrad Solar on behalf of Pittsfield Township.
And Ashley Lundquist for the people.
Assistant Public Defender Natalie Pick, and on behalf of Ms. Conrad, who is approaching. Please state your name for the record, ma'am.
Deanna Conrad.
Thank you.
Thank you, Your Honor. Today's the date and time set for a pretrial hearing, and I'm also prepared to address the bond violation if the court would prefer to start with that.
Yes, wait a minute.
Thank you, Your Honor. So I did receive the violation report. I'm sure the court is in receipt of where my client.
Go ahead.
My client did test positive or did consume alcohol while on bond.
Yes.
She admits that both to community corrections and to me, and she does admit the bond violation today. When I did initially get this report and speak with Miss Conrad regarding the violation, she was immediately forthcoming with me. I did then advise of the warrant, and then she did, under my advice, turn herself in on that warrant this morning. She does take full accountability of the fact that she did consume alcohol and does apologize to the court. She is asking if the court would consider releasing her today, given the fact, and she does recommit to her sobriety and acknowledges to me that she will not consume any further alcohol while on bond. This is a case from 2018. My client does have full-time employment. She works as an inspector for Real Truck, and she is hopeful.
But she didn't even, hold on. I mean, I'll listen to you. Really? That's like the fifth time.
I'm not rolling the next one.
What?
Here's for your honor.
No, I mean, bless you. That's what I meant to say it that way. In this case, she was a 2.55 in a crash. And so while you're talking the time between when that has occurred and where we are now, that's fine, except that then she doesn't make it very long once the conditions are put in place and she's drinking.
She does admit that she drank while on bond, Your Honor, and does take full accountability for that and does apologize for that. It is my understanding, I can't make the representation for sure, but it's my understanding that since this alleged offense in 2018, that there has been no further similar type of conduct. I don't know that for a fact. That is my understanding. However, she does acknowledge that she did violate her bond in this way. I'm asking that she be released today. I believe her to be put on the scram tether, and that she can come back for an adjourned pre-trial date to prove her or show that she does take her compliance seriously to the court. She was always very honest and communicated with me and wanted to take full accountability for her actions. And she did turn herself in this morning on this warrant. And she is asking if the court would allow her to be released.
Right, but wasn't she on a scram before?
Yes, Your Honor.
Well, so, all right. I mean, I'll hear you out, counsel, but I don't know. Why would I release her under the same conditions when in very short order she had violated why would I do the same thing again?
I understand the court's concern, Your Honor. Ms. Conrad, this was a wake-up call getting this warrant. She takes it seriously and did turn herself.
It wasn't a wake-up call just being present in court telling you not to drink?
Your Honor, I believe this was a harsher wake-up call. And I would just ask if the court would consider letting her out and giving her a chance. And I completely understand and Ms. Conrad is fully aware, if she were to violate in any capacity again, in all likelihood, her bond would be revoked until the pendency or till the end of this case.
How did she get
Very
here to
least.
turn herself in?
Pardon me? I don't. Oh, how did she get here to turn herself in? I don't know for a fact.
Can I speak? I'm sorry.
How did you get to the jail?
I was dropped off.
Oh, by
My roommate.
Your Honor, her roommate dropped her off at the gym.
May I ask a question, Your Honor?
Sure.
The violation report the court is reviewing, is that dated, October the 4th?
I do have an October 4th report. That's the one that I'm looking at.
I was confused because when I review this, it says on the second page that the defendant denied alcohol consumption and said he used cough syrup.
I know.
Okay, I'm sorry. I wanted to make.
No.
I had put it differently in court, so I was concerned that there was a revised report that I hadn't received.
Correct.
We'll let the court know as well. There was a 2010 prior offense, so this is at least the defendant's second.
That is correct, Your Honor. She admitted to her first violation of drinking a glass of brandy to community corrections, and then did admit to consuming cough syrup, which technically usually has alcohol in it, and they're provided at community corrections that they should not
Did she
consume.
really drink cough syrup?
Yes, she did.
You did?
Yes. Well, actually, it was Alka-Seltzer plus.
Look at this. Does that not move?
So what are we doing on the case?
I'm asking for an adjournment, Your Honor. My office has not yet received media discovery in this case. I have requested it from the people.
Both of our cases will be adjourned through November 5th, 2025, 9 a.m. I'm just, so it's really two violations all at once. In essence, I mean, because it told her not to drink, she drank. Right? And then I guess presumably then has cough medicine that she can't have while she's on bond. And they go through, you hold your hands up like you didn't know that. They go through that with you. You can't have anything that has any alcohol.
I didn't know Alka-Seltzer Plus.
Your Honor, we are not at all skirting the first violation at all, the alleged one, and Ms. Conrad states to community corrections and to me that she'd consumed liquor brandy on that day. My client is telling me that the report about the cough syrup allegation, and I understand what Your Honor is saying, and I do understand that community corrections provides that information. Ms. Conrad is now telling me it was Alka-Seltzer Plus, and she did not know that may have alcohol in it. But she does acknowledge that first violation, her very first one, and she was immediately honest with community corrections.
Yes,
In the water?
yes.
That's not cough syrup.
Cold medicine. I said I took cold medicine.
Your Honor, my client is stating to me that
I questioned Ms. Conrad about the alcohol detection. She denies consuming any alcohol and states she used cough syrup.
Cold medicine.
Your Honor, my client.
So now you're saying you said something different that's in the
I'm
report?
saying I said cold medicine. I didn't say cough syrup. I said cold medicine.
So you're saying, but you denied consuming any alcohol, but now you're telling me that, huh?
I never denied consuming alcohol.
Your Honor, I believe
brandy-
she's referring to the brandy
Oh.
event that immediately she did admit that she had
Yes.
consumed liquor on that day.
She says. It says here, I questioned Ms. Conrad about alcohol detection. She denies consuming any alcohol. She states she used cough syrup. Where's her admission to the brandy?
On the first page, Your Honor, it states, I questioned Ms. Conrad about this alcohol detection, and she admits to drinking a glass of.
On the, right.
That was after the first alleged violation. On
Right, and then there's another one.
30th.
And so on that one, she says she wasn't drinking
Correct.
and that she had Alka-Seltzer Plus
That is correct, Your Honor.
or something in water that
Computer stuff.
Your Honor, ultimately, Ms. Conrad completely acknowledges she drank brandy. And that
on the
was
one day.
Right.
But here's the problem. If you're an addict and you're telling me on one day, yes, I did it because I got caught. But then comes the next time and you start going through what is the natural thing for most addicts,
Who
a
said-
denial.
Sorry to interrupt.
Saying that everybody got everything wrong. I didn't have any alcohol. It's coughs. I had Alka-Seltzer Plus. So you're saying Alka-Seltzer Plus came up as a positive?
I can't speak to that, Your Honor, but what
Oh, I
I can
can.
speak to is that Miss Conrad was enrolled on this in September 4th. She had a drinking event on September 30th. This was her first contact from Community Corrections about the drinking event, to which she immediately admitted to drinking liquor. She didn't try to make any excuses or say that it was cough syrup, cold medicine, or anything. She was 3 weeks into her bond, just shy of 3 weeks. She drank, she violated her bond. She takes full accountability to that with both the court as well as to Community Corrections. She did then have another event that the Scram Tether picked up on October 3rd. She states to me that she, yes, agrees with that part of the report, that she denied consuming any alcohol. She states to me that she told Community Corrections she took cold medicine. And of course, if that had any alcohol in it, she would not be allowed to do that as to bond, which she now understands. She does admit to drinking
But she's
while on
telling me it's Alka-Seltzer Plus.
as to the second event, yes, Your Honor. And she admits to the first one in complete
Okay, I'm
honesty.
gonna let you go ahead because I'm about so done right now.
She's taking accountability for the bond violation, Your Honor, and she's asking that the court
She's
release her
taking
today.
half accountability. She's not taking full accountability.
So if I say I drink alcohol, will it make a
So here's what I'm gonna do. I'm gonna adjourn this to November 5th, 2025, 9 a.m. for a sentence on her violation and pretrial. Her bond continues as denied. Thank you. Well, not yet so easy. Court does call the case of the people versus Jeffrey Sanders.
Good afternoon, Your Honor. Rita Hannah, Assistant Prosecuting Attorney. I'm back with you.
And Laura Yagi, Assistant Public Defender, on behalf of Mr. Sanders.
All right. And he's,
So, Your Honor,
go ahead.
was the date and time set for preliminary examination. Before we even got to that point, there was some conversation I had with defense counsel regarding proceeding with this case, and also information I received that there is a CPS investigation. That investigation is based on the reports that defendant has been living with, or at least at the very least staying with the victim in violation of his PPO as well as violation of his bond conditions. I informed counsel of that. I know we had a chambers conference regarding that matter. It was the people's position that we were going to ask for remand to keep him in custody until we could have a bond violation hearing and to adjourn the exam to follow. The victim was not present here this morning, although there was some back and forth about whether or not she was on her way. The victim had expressed great fears about showing up here today and what the defendant would do if he knew that she was going to testify. After our chambers conference, Your Honor, I came out to call the victim. There was some conversation about having the victim appear via Zoom. So Deputy Raymond Hall and I called the victim to have a conversation with her about the possibility of her doing that. During that conversation, towards the end of the conversation, she caught our attention as we were hanging up the phone and said the defendant had been texting her throughout this whole day, essentially, throughout this whole procedure, and that she wanted someone to go look for him because he had texted her that he was going to run. I then left the conference room right away. I informed Public Defender Yagi about what we had learned and was looking for the defendant. My understanding at that point from Ms. Yagi was that defendant was going to go use the restroom. I came out in the hallway. That is what he claimed he was doing. I had Deputy Raymond Hall follow him based on what we had just learned. Next thing I know, I was back in the courtroom. I heard police stop. And when I went out in the hallway, defendant was no longer there. And it was my understanding that he had taken off.
And my understanding with reports from security that he took off, that would be the southern emergency entrance out of this building headed in a southerly direction. Ms. Yagi, anything?
Your Honor, I don't think there is anything I need to add at this point.
Based upon that, and this is date and time set for preliminary examination, I'm going to issue a bench warrant for the defendant's failure to appear. There will be no bond. That warrant will issue immediately. I have also marked the file that this matter, initially anyway, it might ultimately be set before Judge Washington, but should be set before me when we get him, and we will.
Thank you.
All right. Thank you. And that was going to be a better. Ready? No. Not letting me. Court does. Can we get Mr. Burke out, please?
I think he should be in custody.
No, I know. Yeah, I know.
They found him, Your Honor, so I don't know. if
Pardon?
the court wanted to, I'm sorry, on Mr. Sanders, they found him, they have him.
They have him?
They have him. Excellent police work. I don't know if the court.
Best in the state.
Do anything today?
Oh, yes. If you guys have time, let's bring him to me.
Your Honor, if I may, I'll go and pick him up right now. He's just around the corner.
Fantastic. I'll be here with bells on. All right, court is standing brief recess. I need that file back.
Yeah. I will pull you in.
Well.
Oh.
You may be seated. Court does call case of the People versus Jeffrey Sanders.
Good afternoon, Your Honor. Marie Tanha, Assistant Prosecuting Attorney on behalf of the people.
And Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Sanders, who is to my right.
Jeffrey Sanders. All right.
Your Honor, before we start, I also just received a text message sent from the victim to the officer in charge, Deputy Hall. It's a screenshot at this stage. Of course, we need to get more information. It's a screenshot from someone named Jeffrey saying, you okay? If you want me in jail, just say so. She says, I don't want you to. That was read by him at 11:42 a.m. Then he says 9 out of 10 times I am. Then he says he back. Then he says, can you talk? Then he says, I'm gonna run. This seems to coincide with what the victim was telling us towards the end of our conversation.
Sorry. So I don't know where you want to start, Ms. Yagi.
I frankly, I don't either. I think what I would request today is that this be set, reset for exam and set for bond violation hearing, because at this point today, I don't feel prepared to go forward on the bond violation aspect. To be candid with the court, I just need more time to talk to Mr. Sanders about these allegations that I just learned about a few hours ago. And I need to go through them in more depth and more detail with Mr. Sanders.
Okay, but just so that we're clear, as we were going through the conversation this morning regarding certain reports and certain other things and certain allegations by the alleged victim in this case, in a lot of ways is referencing his status right now. Aren't those irrelevant to the court? I mean, because, well, I won't say absolutely irrelevant, but for the purposes of today, certainly they're no longer relevant. I mean, even if, which was the court's attempt to try to determine as to whether or not he might pose some threat to the victim in this case, I don't even know that I need to go through that part of the analysis, because clearly he's demonstrated that he's a flight risk. And so he's not going anywhere today. I mean, I hope he enjoyed his little last half hour of freedom. And so, I mean, there's that issue. And also, we were getting indications, and they will get them, that he was texting the victim and he's got a no contact.
I understand.
I mean, I'll set it for a hearing, but I don't know.
I think one of my questions, well, the first question would be, obviously, is there a bond violation? The next question is what is the appropriate sentence for that bond violation? One of the things that I do think is especially relevant is, I do think it would be relevant for the court's consideration in terms of a sentence for a bond violation, the context of the conversations. And I don't have that at this time. And I think it would be important for me to be able to prepare and for the court to have, because, I mean, I don't want to necessarily go further today, but I think it does make a difference if there is contact with someone, versus if someone is calling, texting, and saying, will you respond? And then there's a response. I just think it matters in terms of sentence, even if it doesn't matter in terms of whether or not there's a violation, because one of the things that the state's witness said this morning was that she had been reaching out and asking for a response.
Your Honor, first of all, I'm sorry, may I?
Yes.
First of all, I don't appreciate that my conversation that I had with a victim in this case was overheard, listened to, whatever it may be. The part that's now being put on the record is also a great deal about why that victim did not show up today. And as we witnessed, quite frankly, she probably had good reason not to show today, because I don't know what defendant would have done. And I had to call this victim. I had to have deputies go out and have our victim advocate contact her and essentially tell her, take your kids and run, get out of the house, because that's very likely where he was going. After finding out that she was going to appear on Zoom. I mean, she was willing to appear on Zoom and testify today, despite all her hesitations, and he decides to run, and he's messaging. I cannot imagine a context where that is okay or acceptable or excusable in any way. We're here for a court hearing, and he is messaging her as we're talking to her. So I want to be very clear. I don't think it's appropriate to further put any statements the victim made on the record in front of this defendant, because quite frankly, we're just increasing her risk here. This is high lethality, 100%. And we're not going to contribute to making the risk for her even greater than it is by talking about statements she made in confidence speaking to me. We're just not going to do that. So I would ask Ms. Yagi to stop right there if she's going to get into further anything that has to do with the statements the victim made.
I understand. I will request that it be set for bond violation hearing. I don't feel prepared today to address it. I think there are statements that are discoverable, and so I'll follow up with the prosecutor about that.
Your rig is only level.
An effort to be made to have the victim available next week.
We'll do our best, Your Honor.
All right. So what I'm going to do is I'm going to, first of all, adjourn the preliminary examination. I'm going to keep the case. It would go back to Judge Washington on the 28th, but we'll get it heard sooner if I keep it. So I'll set the preliminary examination for October 21st, 2025, 9 a.m. That will be before me. I'll also set a bond hearing. We'll hear it sometime that day. Bond violation hearing. Anything you want to say before I do what I'm going to do regarding bond?
Not from me, Your Honor.
You know, Mr. Sanders, I'm just going to say this before I do it because I think it's important. your attorney was back there, her and the prosecutor, going back and forth, and I'm sitting there listening. And I tried my best to make sure that every opportunity was at least afforded before any presumption was made regarding any contact, regarding any of that, by having the victim appear via Zoom. And you decide at some point that you are just going to not pay attention to any of these proceedings, do everything your own way. My understanding is you told an officer in the hallway that you weren't going to go anywhere, that you were going to the restroom, knowing darn well that you were just at some point trying to find your way out of this building. I was also informed that at some point, which may lead to additional charges, when they're telling you to stop, you just kept going. And maybe you need to also understand this, that you set off in this building by going out an emergency exit, an incredible amount of protocols in this building to keep everybody here safe when you went out for your little half an hour jaunt wherever the heck you thought you were going, with the thought that you weren't going to get caught. If the court had made up its mind that I wasn't going to incarcerate you, you changed that. This is all you. Because as I've indicated, I have to be concerned about two things. One, at least before now, I wasn't concerned about you being a risk of flight, but I have to be concerned about that. And I have to be concerned also about the protection of the public, but particularly the victim in this case. My heart of hearts tells me that at some point, that's where you were headed. To terrorize her more. Because you were gone. And because you laughed, had all kinds of court security down this way, trying to figure out what was going on. All kinds of debt. You threw law enforcement into this whole world of trying to find you. At the same time, trying to protect her and those 4 children. Because there was no telling what she would do. So you might as well get used to one thing. You've shown me what you are at this point. I don't have to try to hear a whole lot from people about what you are. Because I think you were going after her. And I'm going to tell you, on my watch, that's not going to happen. Defendant's previous bond is canceled. Defendant's bond is hereby ordered revoked. Defendant is remanded.
Yeah.
Is that it? 14A stands adjourned. I'm good.
That's my wife in the truck here.
Hello, Tariq Samar, Tariq Day here.
Red Judge, Torshio Feaster, Assistant Public Defender on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office representing me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
It's going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had another counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here. So I don't know what's going on, Your Honor.
No,
Mr. Day?
I'm defending myself. I told him I would notify the court that I relieved him of any implied obligations to this case.
So you're gonna represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now,
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no
you
way I
have
can.
in a vehicle with a hat on, no mask. Oh,
I am inside my vehicle right now.
what'd you say?
I said yes because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you
So
go
there's
to
no-
the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're gonna do. Then I'm gonna say, okay, you've got COVID. I want you here, when's our last block? 3 o'clock today, wear a mask. If you're gonna represent yourself.
I can't make that. Is there a later date?
Oh,
3:30?
yeah, you can. 3 o'clock.
3:30, I can make that.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then we can.
Okay, and at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line. Why don't we do this? Give me about 3 minutes. I'm gonna take a recess, then I'm gonna come back because everything's going downhill and it's those two guys' fault. What's your name?
Tariq Samar Tariq, the executive of the Tariq Samar Tariq Living Trust. Owner, Tariq Wilson Estate.
Sir, you indicated that you wish to represent yourself on this matter?
Yes.
All right, you understand at your arraignment, you were given the charges that were filed, have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding.
Fleeing and eluding 3rd degree.
3rd degree, correct. And if anything else was tallied onto that, then I was not told.
Okay. I have 1 charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
As soon as I get through this, you have indicated that you wish to represent yourself. I have to advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. You understand that, sir?
Correct, I comprehend.
All right. You also, so I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and wish to be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
How do you wish to proceed on this matter, sir?
First, I want to like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of a personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing. and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department. Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser, with the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Done. Finished?
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust. And I'll be able to supply you all with the adequate assurance certificate of security to settle and offset the charges.
Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing.
This is a probable cause hearing.
So I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Put this on.
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was.
You weren't able to do what?
Provide my exhibits.
To whom?
To the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point. So they will be here, if not by the end of the day in the drop-off box, and you'll have them tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not at this time.
All right. So how would you like to proceed next on this?
Entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer. There was
You stood mute, you stood demurrer. You don't even know what that means. You're just using words and have no concept as to what they mean.
Demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not. They are not.
I'm not here.
They are virtually the same thing. So where do you wish to proceed now?
As I stated, my motion.
Do you wish this set for preliminary examination? Your motions have been denied.
I wish for the prosecution to provide the evidence that any of this needs.
You don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about it.
Do you wish to have
Discovery
discovery?
should be provided.
Don't play word games with me.
I'm not playing.
Mr. Allen,
Discovery,
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning. I will ask you again. Do you wish to have discovery provided to you?
Yes.
Do we have copies of discovery available that can be provided to this defendant?
No, Your Honor, I know that the PD was representing this individual. I don't have copies right now.
I got you. Okay. Mansour, are there copies of the police report as well as other discovery that's in the hands of the public defender's office?
I do see traffic stops and discovery videos onto our program.
All right.
Documents.
All right. Those need to be gotten to the defendant.
Yes, sir.
How soon can those be gotten to the defendant?
I can get those in hopefully by tomorrow around.
You have an address for him to send those to him?
Yes, I do. I can confirm it with him too.
All right. What do you have as the address? Do you have an address on, is it Share?
I do, Your Honor.
Okay. Okay, gotcha. All right. You'll make sure that that is sent to him.
I will.
You also have an email address so that all things can be emailed to him also.
I do, Your Honor.
All right. Very good. Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing.
What kind of jurisdiction here?
Personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threat and duress of coercion of you, saying that you would hope put out a bench warrant for my arrest. The subject matter, in regards to the name as well as the vessel that was used, is again under. It was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly and the trust is properly functioning at this time. So with that.
All right. So here's what we'll do, because you're rambling again. So what we will do is you will put all of your jurisdictional arguments in writing because you're wrong. So we might as well get it in writing that you're wrong, because I have subject matter jurisdiction over you and I have personal jurisdiction over you under the Constitution of the United States and the Constitution of the state of Michigan. So if you want to put your objections to jurisdiction in writing, you may do so, and then I will address those in due course.
Awesome. So that would be the next step, and I can get those in today.
No, that is not the next step. Either you're going to have another PCC. If you want me to set it for a hearing, I'll set it for a hearing.
Yeah, for the jurisdiction.
But I have nothing to set a hearing on. You have not filed anything regarding jurisdiction.
Okay, so for right now, as of this moment, PCC is fine. And then I will file the proper documents for the jurisdictional hearing. Gotcha.
Well, I basically bought this roof over the internet, which wasn't something I'd ever done before, but it worked out real well. I was scrolling through Facebook and I found this ad by the Metal Roof Consortium. So I entered my information and they contacted me. After I answered the Metal Roof Consortium's ad, they explained to me that they didn't even have to come out to the house to measure anything. They could do it by satellite. And so that's what they did. And then they emailed me the estimate. I mean, it was so easy. That worked for me, and that will work for me in the future.
Have you been thinking about getting a quote for a metal roof, but have been putting it off because you just don't want a pushy salesman coming out to the house? Or maybe you're just too busy and you don't have the time for someone to come out. Either way, we have a simple solution for you. Hi, my name is Ross Tebow, and I represent the United States Metal Roofing Consortium. As a consortium, we install metal roofing all over the country. Using satellite technology, our estimators remotely calculate certified accurate quotes nationwide each and every day. We answer any questions or concerns our customers have via email, Zoom calls, text, and by phone. So here's how we do it. Simply click the link below and fill out the form on the next page. Don't worry, we will not share your information. Once we receive your info, we order a certified accurate satellite measurement of your property, like the example shown on the screen. The satellite measurement gives us every detail concerning your roof. It tells us the number of squares needed to complete the roof, the number of hips and ridges, how many feet of starter, etc. It also tells us the pitch or the steepness of the roof. It tells us how much waste to factor in.
So I'll adjourn the probable cause conference in this case, April 25th, 2024 at 3 p.m.
Is it possible to get another week for
person
to provide to accumulate my documents for my defense?
Is there what?
Is it possible to have that extended out another week so that I can provide my?
I'm going to set it 25th.
I mean, I was on the call. I've heard you give multiple counsels extended times. So what is the bias?
I have no bias against you, sir.
Well, I'm simply asking for
I'm
a reasonable
setting the date of 2 weeks out. You can have your motion together, file your motion. I will be able to address your motion at that time so that we can get this headed to a PC, to a preliminary examination.
Just for the record, I put it on the record that I object, but under threat, duress, or coercion. Again,
your objection is noted.
Right, and under threat and duress and coercion, I'll be here.
Court does call the case, People versus Tariq Day.
Senior Assistant Prosecutor.
I am Tariq Tariq Day, the executor of the Tariq Tariq Day Living Trust and the registered owner of the Tariq Tariq Day Ex Relatione Kingdom Wilson Estate.
Right. So you are appearing here without an attorney. I do have to advise you that you are charged with the offense of fleeing and eluding in the 3rd degree under the Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration and or a $1,000 fine plus court costs. Additionally, the Secretary of State could suspend your driving privileges for up to a year. Do you understand that, sir?
I comprehend.
Do you understand?
I comprehend, yes.
The court has to further advise you that if you wish to be represented by counsel, the court would ensure that counsel would be appointed to represent you in this matter, and that you would have counsel if you could not afford to hire counsel yourself. I also wish to advise you that the court would be treating you the same as it would the people in this case. There are certain dangers to representing yourself in this matter. In that you will be required to abide by the Michigan court rules, the Michigan rules of evidence, and all of the cases and statutory requirements. You understand that?
I do not.
You do not. What is it about that that you do not understand?
It's against my religion to adhere or to assimilate to any statutory.
Sir, I'm not asking anything about your religion. It is irrelevant. Indicating that in this proceeding, you will be required to abide by the rules of this court. Do you understand that?
I'm having a hard time understanding why or how religion doesn't play a role.
How what?
How religion does not play a role.
Religion does not play a role in what I do or what this court does. There are certain rules of this court established by the legislature and the Michigan Supreme Court regarding how these particular proceedings will be conducted. These proceedings will be conducted in accord with those rules. Do you understand that, sir?
Well, according to the American Declaration on the Rights of Indigenous Peoples, as well as the international or the United Nations Declaration on the Rights of Indigenous Peoples, the state and the governments should.
Sir, you have no authority for what you're about to state because what you're about to state is incorrect.
Oh, I am an Indigenous person.
No,
so I do have
sir, what you're about to state is incorrect.
You're invited to join Phoenix Energy's next webinar.
Well,
if you were on indigenous lands, if that's where you're going, then maybe you might be right. As it stands right now, this proceeding is not on indigenous land.
Well, that's a matter of perspective, sir.
It is, and the only perspective that's going to matter on that is mine. We are not on indigenous lands subject to indigenous or tribal rules. You are subject to the rules of the Michigan Supreme Court as they are promulgated, both in terms of procedure and evidence. Do you understand that that's what's happening, sir?
I do not.
What is it that you do not understand?
I don't understand.
Because I'm going to tell you something, sir. If you are unable to establish or understand what I'm saying, and go through this with you again, I have to assume.
Hold on. A new picture of Lisa has come forward. Oh God. I gotta send that to Megan. I gotta send that one to Megan. Definitely got to send that one to Megan. Ah, that's too funny.
That there may be some reason why you don't understand. This court will take precautions to protect your rights, and I will be sending you for a competency evaluation to make sure that you are competent to stand trial and to stand in these proceedings.
Well, I would agree to a competency if the prosecution as well as the court and the officers agree to take a
That's
competency.
not the way it works. You don't get to make the rules.
I'm not.
I'm ordering a competency.
I'm not making.
Defendant is ordered for a forensic evaluation. I will set a competency hearing this matter for July 25th, 2024. At what time? At 9 a.m. Now, sir, I'm going to ask you this.
Yes, sir.
Because it's going to depend on where you may be staying for a period of time. If they send you information as to when you have your forensic interview,
Yes, sir.
are you going to cooperate and attend that interview?
Under threat, duress, and coercion, yes.
Pardon?
Under threat, duress, and coercion, yes.
No. It's not how it works. I'm asking you, are you voluntarily going to cooperate?
I say yes. I mean, under it, yeah. I mean, is this what are, excuse me, what are you relaying to in regard? What are you insinuating in regards to where I will stay for a time?
I'm going to make sure that we are going to have our forensic interview done. I've ordered a forensic interview. I am asking you whether or not, when given notice of that interview, whether or not you are going to voluntarily cooperate in that interview.
I will take the interview.
Excuse me?
I will take the interview.
Stop buying generic Viagra and try this new.
Anything from the people?
Would the court ask the people to prepare the order for the competency?
Yes, please prepare the order for the competency if you would, sir.
And the address for
The defendant.
I see on the complaint is 1410 Share Avenue, apartment number 3.
Is that your address, sir?
Excuse me? That's correct.
All right, very good.
And so I will send a copy to that address.
Very good. All right. This time then bond is continued.
Yes, sir. And I'm sorry, can I get that date again, please, sir? I can put it in my calendar.
July 25th. You were supposed to, so I'm assuming you're waiving it. You were supposed to file your motion with.
I did.
the court.
I filed it.
When did you file it?
I brought it in today.
Do we have it?
I gave it, I mean, it was stamped and everything. I gave it to the reception.
Why didn't you file it before?
Well, as I stated at the last hearing.
No, don't go through what you stated at the last hearing.
Well, you
You
asked.
knew that, no, you knew it was supposed to be filed before the day. And man, you're gonna
That's it.
figure out something. We're playing by my rules, not yours. So you know, do not say anything because you're gonna figure that out real soon. Do they have it?
I have not received a response yet.
Since I'm sending in for a competency, I can't hear that. I can't hear his motion in any event. So I won't hear his motion at this time. He'll have to refile it timely if he's determined to be competent. So I'll have his bond continue. He can go. What?
I didn't get the last part that you said. The bond continued and what?
I said you can go.
Oh, okay, no problem.
Then came the turning point. the competency evaluation order. Now, this isn't a punishment, it's a safeguard. When a defendant shows they don't fully understand the proceedings or
Calls case people, well, is she in? Got it. Court calls case people versus Joshua Wara.
Government vote for the people.
Mr. LeBeau's case. Wara.
Joshua Wara. Thank you, Your Honor. Mr. Wara, can you state your name, sir?
My name is Joshua William Wara. I'm representing myself in this case.
So you don't want to be represented by an attorney?
No.
Okay. All right. Well, I would say there come some perils with you representing yourself. You understand that, sir?
No. I know
You
the
don't
mission
understand?
I'm a jailhouse lawyer.
Pardon?
I know what I'm doing. You are working.
I'm sorry?
You are being paid by Adolph Mack to fry me. This is conspiracy for murder. Your wife, Delphia Simpson, came up here pretending to be Ann Arbor Comprehensive Care Center yesterday. You are originally the Tux family. You are an Egyptian lord. You're Illuminati. If you do not help me,
I'm Illuminati.
I will sue you and criminally prosecute to the fullest extent.
Okay, I welcome that. You're invited
Thank
to
you,
do so.
Cedric Simpson.
What do you want? What do you want to do with your case today?
Ellen Wara, Adolph Mack, Jeffrey Peak, Cynthia Miller, Frank Stanton tried to set me up, along with Derek Miller and Ryan Miller.
Okay,
They're
but
the
I've got to
Ku
do
Klux
something. I've got
Klans.
to do something. I've got to
With
do
the
something with your
MDOC.
case.
Huh?
I've got to do something with your case. What do you want me to do?
I would like to sue, and what am I in court for today? And I would like to prosecute to the fullest extent.
Okay, so
And
let
I
me
can
do
sue
this.
for
If
10
you-
times
if
the amount of what was stolen from me. They stole $666.8 million from me. They then turned it into 5.5 trillion and then put a hit out on me. I legally can sue for 10 times that amount, which would be $550 trillion. And I can criminally prosecute to the
No,
fullest
I'm with you.
extent, which is
I'm
my
with you.
right.
I did the math too. Listen, here's the thing.
Mhm.
I have to advise you, because if you are going to represent yourself, what you're here on, okay?
I'm doing it over Zoom. 'cause they're
So
trying
you're
to kill
here
me.
on a complaint that alleges that on October 15, 2025 on South Main Street
The Pentagon's
in the
using
city of
prism to
Ann
make
Arbor,
the
Washington
Zoom,
County,
mess up.
that you failed to stop at the scene of an accident regarding resulting in serious impairment or death. Do you understand that charge?
$1 trillion.
Yeah, sure. And that's a felony, punishable by up to 5 years incarceration, a $5,000 fine plus court costs.
Which is actually 10 times the amount, because I can sue because it's conspiracy to murder, and sovereign law would make it 100 times the amount, but since it is conspiracy to murder, sovereign
I'm
law
with
does
you.
not
I
exist.
got you. I just have to let you know what you're charged
means
with.
I can sue for
There's
1,000
also
times the
count
amount.
2 on the complaint that alleges that on that same date and at that same time, that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yes.
Okay, so there are serious perils representing yourself as opposed to having counsel. I would just have to advise you, you'd be treated the same. You are charged with making sure that you have an understanding and that you abide by the Michigan rules of that you abide by the rules of evidence and the rules of procedure. You understand that?
Yes, Cedric Simpson.
All right. And the other thing that I have to advise you of is that at any point during these proceedings, you wish to have counsel,
No, I do
Then all
not
you
want
have to
any
do is
counsel, and I
just
want a bench
listen-
trial,
listen
not
to
a
what
jury
I'm
trial.
saying.
Because a bench
And
trial
then
is
if at
based
any point you
on
do,
objective evidence.
if
A
at
bench
any
trial
point
is
you
subjective
do
evidence.
want counsel, you just have to let the court know and the court will make sure that you have counsel.
No,
You
I do not
understand
want
that?
counsel.
Okay, so what do you want me to do with your case today?
I
Now
would like
that
to
I've
do a
gotten through
bench
that
trial
part.
because a bench trial is on subjective
bench
evidence
trial?
and a jury
Well,
trial
that's
can
not
be
gonna happen.
bribed. And they're trying to
Okay,
bribe the
you
jury.
can go to
So
circuit
I
court and
want
have a
to
bench trial.
prosecute with sovereign law, and it's conspiracy to murder, and Donald Trump and Elon Musk are involved, and I can sue for 1,000 times the amount. And sovereignty
Your Honor,
does
if I
not
can
exist
if I
because the
can-
amount of money that
I
they
don't know,
put
I've not
that
been
out
very
on
good at
me,
it, but.
and Donald Trump and Elon Musk and Adolf
So-
Mack and Doug Minkoff and Jeffrey Peak and Ellen Wara all have estates that and residencies in states that do apply the death penalty. I would like to get.
Okay,
Mack
okay, I'm
and
with you.
Chair.
I got you. Let me hear from somebody else real quick.
Your Honor, if I was working with Mr. LeBeau on this file, I was going to be asking for an adjournment as this is a new file. The defendant is on surveillance video at the intersection of this crash causing this accident and then fleeing the scene. That has not been provided to either the defendant or his attorney if he has
I'd like to
one.
give
So
Donald
we would
Trump the
need more
elected
time.
chair.
The defendant's on parole, and if he's entertaining the idea of representing himself, I think it's important that we refer him to first.
Well, I don't know that I can do that right this second, although maybe. But here's what I'm gonna do. Sir,
Cedric Simpson.
I'm gonna adjourn your
I do
case
not want
out.
a jury trial. You cannot adjourn this. This is a high profile case. Where I can't again.
Okay, but you
There are
haven't
too
seen
many
the
people involved.
You
You have a
haven't seen
Neuralink in your brain and you are being manipulated and bribed and conspired against for murder by the Nazis. You will work with me.
Alrighty then. So you don't want an adjournment?
No, I do not want an adjournment. I want a bench trial.
Okay, so
It's based on
listen.
factual evidence. The jury trial can be bribed.
I hear you. So the only thing that can happen is I can set this for a preliminary examination, but you haven't seen all the evidence.
I don't need all the evidence. I know all the evidence. Let me get a discovery
Okay, then.
packet though, so I can represent
So-
myself though, please. With all evidence, I would like to.
You
subpoena
want to represent
phone records
yourself?
and all evidence.
All right, listen. Okay.
I would like to
So you want this
subpoena
set for
Bill
preliminary
Juarez.
examination?
I would like to subpoena Bill Wara. I would like to subpoena Scott Casey, the Michigan militia, all of their phones, Doug Minkoff, Jeffrey Peak, Adolf Mack, Donald
We're not
Trump,
bringing out those people
Elon
down.
Musk.
Yeah, okay. If you want to subpoena them, then you can. But I'm not bringing all those folks. My problem is he's asked for his exam. So I will have to set it. I wonder who'd like to hear this.
Your Honor, would we still be on the case?
Hang on, I'll get to that in a minute.
Thank you, Your Honor.
So I'm gonna indicate he doesn't want his discovery. Says he doesn't need it. Would they, man? I'm not gonna have the complaint that's rights have been infringed, so yes, I'm gonna do it. And you're gonna be mad. It's okay.
You don't care about my feelings.
I don't care about your feelings because you don't care about mine. But we shouldn't air this in public. No, I have to do the, no, I can't. I cannot. So I have to do it. I got you.
Okay.
I hear you, but I can't do that. So here's what I'm gonna do. I'm gonna set this for defendant invoking what he has. Would prosecutor have their witnesses available the 28th?
Yes, sir.
Sir, I'm gonna
Yes.
give you your preliminary examination. So your preliminary examination will be set in person on.
Your Honor, I'm so used to just
And,
saying, yes, sir.
Adolf
No, I
Hitler
know,
is in
but
the
I
judicial
realize it's
court
close, but.
with Carol Conkey and East Hope, et cetera, et cetera.
Excuse me?
Carol Conkey is involved. She is at 22nd Judicial Circuit Court with Feiger and Ellen Warren and Jeffrey Peake. Elon Musk is with Trump at the Michigan Supreme Court in Lansing. I do not want to adjourn. I want a bench trial.
I am not adjourning. I'm giving you the quickest preliminary examination I possibly can.
Yes, sir.
But I have to hear from all sides regarding that. I would set it for the 28th. Counsel, most of these witnesses are police witnesses, so we could at least begin.
Okay, thank you. What's today?
That's a yes or no.
Yes, sir.
Thank you.
Today, Cedric Simpson?
Pardon?
What is today, Cedric Simpson?
Today is the 23rd.
Okay, Miss Lee, I'm sorry that I'm executing your husband.
You're executing what?
Miss Lee's husband, who is Adolf Mack. I'm giving him the electric chair. And I'm suing him for everything he owns. He's JP Chase Morgan. He owns Chase Bank. I want Chase Bank. He's Hitler.
Okay. All right.
I'm suing for Chase Bank and giving JP Morgan Chase, who is Adolf Mack, the electric chair.
Okay,
If
thank
Elon
you.
Musk works with me.
Okay, so here's what I'm going to do.
And Donald Trump.
I don't know that we'll be able to go given how you're
Yes,
acting.
we will.
but
I want
I'm
a
going to
bench
set
trial
your
today.
preliminary examination.
I am sorry, Cedric Simpson, that the and Adolf Mack, JP Morgan.
I'm going to set your preliminary examination for October 28th, 2025, 9 a.m. That will be before me. You know, I'm not, if I let the PD off, because I may on my own motion be referring for competency, I will do it that day. But so right now, to answer your question, Mr. LeBeau, you are still on the case because I think the more the merrier.
Thank you, Your Honor.
People.
Allie Zend on behalf of the people, Your Honor. And good afternoon again, Your Honor. Miles Drew on behalf of Mr. Busick, who's approaching my right. And can you please state your name for the record?
Ryan Michael Busick.
All right, thank you. Go ahead. This is your motion.
Thank you, Your Honor. At this time, the people are going to be requesting our original request of a $50,000 cash surety bond. In this case, defendant was granted a PR bond. However, the facts of this case are extremely concerning. In this case, the defendant went to the victim's residence and was almost interrogating her and accusing her of infidelity. He banged on the door, was told to leave by her. He then forced his way into the home, breaking the door. Officers, when they arrived, saw broken drywall, the door was off the frame, the lock, the deadbolt was still in the lock position. After entering the house, the defendant then grabbed the victim and threw her onto a bed and was continuing to interrogate her about who she had at the residence. He then pulled down his pants underwear to his knees, exposing himself, and she stated that he then tried to rape her. While this was happening, he was continuing to interrogate her about infidelity. She was then able to kick the defendant, run away out of the room, and exit the home, where she began to yell for help. Neighbors heard her calling for help. After that, the defendant then proceeded to chase her down and tried to stop her by grabbing her arm, causing her to fall. Law enforcement arrived shortly after, and in the videos, you see that they both, it was raining, and they were both covered in rain, I guess water, I don't know. But it's very concerning, especially given that there was the broken door. And then not only after that, when he gets into custody, one of the two calls he makes, while one of them was prior to bond conditions, it was concerning to the people, given that in that call, he continues that line of interrogation of accusing her of cheating and infidelity on the jail calls. And then the next day, when he's arraigned, after he's arraigned, he calls her again, violating his bond. And it just seems, especially given these emails that we received yesterday, he has this obsessive disposition with this victim. And it's very concerning to people, given the facts of this case and his actions after this case occurs. So at this time, we're going to be re-requesting our $50,000 request. I believe that a personal recognizance bond was an abuse of discretion, Your Honor.
Ms. Franz.
And Your Honor, we would admit that there was a call that occurred in the jail line, the one call that is a violation of the court's bond conditions for the no contact. I would note that all the allegations the prosecutor has gone over as it relates to the bond violations were prior to me being retained as counsel. Mr. Busick's a lifelong resident of Ypsilanti. He has a clean iChat that I've seen, meaning he has no priors and accordingly no capious history. While this is a very serious charge, and Mr. Busick does contest the allegations and is serious about facing them as evidenced by retaining counsel, I would note that there was no injuries or medical treatment and that Mr. Busick did comply with police officers. While I'm not here to litigate the facts of this case in a bond hearing, I think it's evident from looking at this case and the pending case against the complaining witness, where my client is the victim, that they have a dysfunctional long-term relationship that will no longer work out in any capacity as a romantic relationship. I've expressed that to Mr. Busick, and he's been receptive to that feedback. I think it's clear that neither party has treated each other very well. He is living currently in Ypsilanti with his mother, Lisa, who is in court today, his stepdad, Doug, who is also in court today, sister Chelsea, who is not here, but has been in constant communication in my office. His sister Erica is here in court, so he has strong family support in this matter. He does have 2 children with the complaining witness in this matter, his son Matthew, 4 years old, and daughter Scarlett, 2 years old. It's a shared custody situation where he has the kids on the weekend and about 2 or 3 nights during the week. His mom and sister are facilitating those custody exchanges. And I have expressed not only to Mr. Busick, but to the family, the importance of the no contact order, including that it means no third party contact, and have instructed the family not to discuss this case in any capacity whatsoever with the complaining witness. As for work, Mr. Busick is a journeyman carpenter with the Regional Carpenters and Millwright Union. He has over 10 years experience and 6 years with the union. He has good health coverage through his job that provides for not only him, but his children with the complaining witness. It's our understanding that the complaining witness does not work. And even though there's no child support order in place, he does also provide support to the mother of his children for expenses when she has the kids in her possession. In other words, he is the provider for these children, and they get their health insurance through his job. And that appears to be the only avenue for their health insurance. And he is at risk of losing this job should he go to jail. So, Your Honor, I would, conclude by saying that counsel was retained after all these allegations, that Mr. Busick has no prior criminal record. And I think him and the family maybe didn't understand the scope and importance and severity of a no contact order. I have counseled them at length about that no contact means for any reason.
You have understood about that, counsel?
Your Honor, I think it's somewhat common for people. I know no contact means no contact, and it's very straightforward, but I think people that have no prior history with the criminal justice system sometimes do not think things are as straightforward as they are. He certainly makes no excuses for his behavior, and he knows it's inexcusable to make those calls. We would be asking for a $25,000, 10% with the tether.
But he's still, I mean, from the allegations, I mean, and I'm not making necessarily a presumption of his guilt of those, but he's making certain allegations regarding her infidelity, then ultimately gets arrested. I mean, after creating, I guess, some damage or allegedly creating some damage to the premises, and things not going well because now you're in custody, you're told by the magistrate not to have contact, and what does he do? He has contact. And about the same thing that the allegations are about.
Right, I understand the court's concerns. That's why we are asking for a cash bond in this matter. I would point out that, since he was assaulted in March by the complaining witness, which resulted in felonious charges, these have been some of the hardest and trying months of his life. He has not been in his right state of mind. We're going to be looking to getting him, treatment while on bond and getting evaluated for a treatment course so he can get some support in facing this tough time, Judge. Ultimately, there's no excuse for making the phone call on bond. We understand that the allegations are concerning. We can test them as it relates to the case.
Tell me how I can even be sure that he's going to follow this court's conditions.
Well, I think you have his family sitting right here in the courtroom, that they're accountable, good members of our society that are going to be looking out and holding him accountable. They have, financial interests involved in this case as well. They are living with Ryan. He has no prior record, which I think speaks to the fact that they raised him pretty well up to this trying point here. And I think that the tether, was put in place after these phone calls, and there's been no issues with the exclusion zone. So I think in that respect, the tether is working, Judge. And I think you have members of the community that will be looking out to ensure that your court order is followed by Mr. Busick. And I think this is a real wake-up call for him, quite frankly. This isn't a situation he's used to being into, given his clean criminal record. And I think he's standing up a little bit straighter now after this and understands just how much is on the line after having a stern talking with counsel both last night and prior to court today about the severity of the situation that he's in here, Judge.
In the 14B case, isn't there a no contact?
There is a no contact order in place.
So what's he doing there? I mean, that's the part that's troublesome to me. He has a case in which he's the alleged victim, right, counsel?
Correct.
He knows there's a no contact provision, right?
Yes. Well, the no contact provision would run to the defendant in that case, which is the complaining witness in this case.
How it works. That's not my point. My point is, why is him knowing that? Why is he at her residence?
Well, Your Honor, I would say that I think, these no contact orders, I mean, he shouldn't have been seeing her, but this is a 10-year relationship that goes back to when they were 16 years old. They have children in common. While I certainly would have liked if this was handled.
So that's all fine and dandy. But he knows she's not supposed to have contact, right?
Well, he believed the condition was dropped. But I mean, I would agree that he should not be having contact.
Where would he get the idea that it was dropped?
I'm not sure, Your Honor.
I don't believe that for a minute. I mean, he knows she's not supposed to. I mean, I'll tell you what it sounds like to me. Sounds like to me, he's intending on getting the upper hand. So he goes over there and he can basically, in essence, force her to give whatever answers he wants, because the one thing at least he knows or thinks is that if he calls the police, she's in violation, I'm not.
No, I don't think that that's the situation going on. I mean, when the police officers did bring up the no contact order on the scene, he said that he had thought it had been dropped. I think he's simply concerned about, these beliefs of infidelity, Your Honor. It's an improper way of going about it without doubt. But given that he has no record, he hasn't had any trying situations, he's only 26 years old, any trying situations like this in his life, I would view this as kind of a one-off situation, that now that he has the accountability structure in place with his family being aware of what's going on, being in the courtroom here supporting him, that this type of behavior would not continue. And I expect him to comply with all court orders going forward, Judge.
Anything else from people?
Nothing. I mean, I just have concerns given what the court stated with the no contact order in the 14B case, and given that the victim in her interview with police at the scene states that they're separating. So I don't know why he would go to her residence to accuse her of this break-in and assault her. I just don't understand. But nothing else from the people as far as this goes, Your Honor.
Oh, right. And I think you know this, counsel. What I really should do is I should revoke his bond. He doesn't make it a day before he's violating the bond condition.
I understand the court's concern.
This is not just, it's not. What is troublesome for me is that he violates the bond condition. And when you look at the transcript of what he's talking about, in the very first part, it's just a continuation of what got him there in the first place.
And I think this, sorry.
Go ahead.
I was gonna say, I think the stern talking to that I've had with both him and his family about the, concerning nature of these allegations, the phone call transcript, I think that he's been very receptive to my feedback, and I don't see that this being an issue going forward. This was, within a day of the incident, his emotions were still very, high in charge. It's obviously no excuse for doing what he did, but given that—
Counsel, that's part of my problem. Part of my problem is it doesn't seem that he can de-escalate, because he gets involved in this thing, gets arrested. This fixation that he has on this infidelity, even after he's arraigned, even after he's warned, admonished what he can do, what he can't do. Within hours of that, he can't step back. He just can't.
I understand the court's concern. I would say, while I would not have advised him to send any of those emails to the court, the fact that he's reaching out to the court, not to her, is some indication of change from the, Friday before.
No, it's really not.
He's not reaching out to her. I certainly would not have advised him to send those emails, and I have instructed him going forward not to do anything like that and to run anything he's doing with these cases through counsel going forward.
Listen.
Even the emails are concerning. In the emails, he's trying to get her in trouble, trying to use this as leverage against her in the other case. And he just can't stop. Even if it's not contacting her, it's this continued obsessive feelings towards this victim.
I'm certainly not pleased with the emails being sent, but I would note that it does appear that there are potentially bond violations on the other case. That's not a concern for this court here. But it's not like he's making up and frivolous.
Why is it even his?
Your Honor, I have no good explanation for that.
Tell me what's your client's purpose in sending those to the court? What was the purpose in sending those to the court?
Wanted to alert them of the bond violations that have been alerted of in his case, Your Honor. It's not anything that he's proud of, but he was going to change his actions going forward.
It's not my court. He knows what court it's in. Why is he sending it here?
I think people commonly get confused about the 14th.
Counsel, look at the very first email. He's not confused because he's real clear about what he thinks is happening with her defaming him.
I meant the confusion about 14A or 14B, Judge. I understand.
No, I'm saying, why did he send it here? I'm not the judge. He knows it. He's not confused about what court it is at all.
Well, I think he did believe he was reporting it to the court of record, albeit mistakenly, Judge.
Is he going to tell me that if I put him under oath that he thinks he's sending it to the right place?
Yes, he was.
There is no way. Why is it coming right now?
I sent it.
When were those videos taken? When were those videos taken?
About a month ago. And that was...
She's got a winter sweater on in like May? Really? So if you had them for a month and you think you're contacting that court, what took you so long?
There's no excuse for the timing.
No, what took him so long? This is his story. He's trying to convince me that he can behave.
Would you like me to speak?
Go ahead.
So I didn't want to contact the court because, yes, we were working on things, and I spoke in front of you, and I believe that the no contact was dropped so we could start to work on things. I came in front of you and said that during her case one day.
Your Honor, I would note that it was charged as a felony case, and I know you typically sit on the PCC docket, so you may have been a judge that appeared on that case at some point. My understanding is that currently it is just the misdemeanor domestic violence charge that is still pending against the complaining witness, but I do believe it was a felony case where it's possible you would have been a judge that sat on that docket.
And Your Honor, if the court does remember, you were on that case for PCCs, but the people had declined to address the no contact and change it, given concerns of the case.
I do believe that. I think we believe that. If you were looking to report these month-old alleged bond violations, why did the court need to know that now she's defaming you?
I just said there's no excuse for slander.
There's no excuse for the slander, man.
What?
No excuse for the slander.
Yeah, but how is that a bond violation?
I believe there was an understanding from Mr. Busick that there was some kind of no alcohol or no drug provision as part of her pretrial release order. I believe that's what he understood. Whether that is or is not the case, I'm not sure, Judge.
But then it says, and is now causing defamation against me. Why is that important to the other court?
It's not.
Yeah, it's only important to this court.
Correct.
In this bond hearing.
And I did believe that it was still here. I didn't know it was at 14B.
How come you didn't go through your attorney to send this?
I was not retained at that time, Your Honor.
No, he had a PD at the time. Why didn't you go through her?
I did try to call her that morning after speaking to the prosecutors, I believe. But I was at work and I missed her call back.
When, yesterday?
Yesterday, yes.
So you just decided that you just send it?
Well, yeah, so I did. I called the courthouse on my break and I said, you know, where do I contact for breaking bond? I should not have, Your Honor.
Why was it so important for you to report her breaking bond? Let's assume it to be true. Why was that so important right now?
Well,
careful how you answer me.
Correct.
Because no, listen. Why was it so important to do that? You had just received an emergency bond motion to change your bond. You then start sending stuff. Why is it so important to now report what you say is a month old? I think they're older than that. The month-old video. Why is it so important to do that this week?
I wasn't thinking, Your Honor.
Why was it so important? I don't care. What was your thinking? Whether clear or not, what was your thinking?
Say something to me.
I mean, I really wasn't thinking. I really wasn't thinking clearly. I'm not too sure.
I suspect the court could hear Mr. Busick there. I mean, he has no justification. He clearly wasn't thinking straight. I mean, I think he was feeling the pressure of the bond violations in this case, was aware that, or thought he was aware that she may be violating her bond. There's no good justification. There's no answer that we're going to provide you, Judge, that ultimately satisfies you.
So what makes me not believe that as he feels the pressure of this case, that he doesn't lash out, do something?
Well, I think his children.
Why would I believe that? He had counsel at the time.
I don't think he had the same trust relationship with that counsel that he has now. And I think knowing how much his children's health care is on the line because of this, because his job is on the line,
It's all on the line. It was
Absolutely.
on the line after he was arrested. It was on the line when he made that call. It was on the line when he starts sending these emails. It's always been on the line. I don't know why he can't recognize that. And that leads me to believe that no matter what I tell him, he can't do it. If he doesn't understand that from the very beginning, what's at stake? And I do believe that he went over to that unit. He went over there to get her in trouble, just like these emails. That's what he's doing.
No, I don't think that the facts when the case is litigated will show that that was his intention at all, Your Honor. I understand the court having concerns, but I think not only, my talking with him, but now this, bond violation hearing in front of his parents, I think he's going to be standing much straighter. I think he understands it. I wish he was a quicker learner.
It shouldn't take his parents to make him stand up and do right.
It doesn't, Your Honor. I think that he'll prove that going forward on bond. And I think bond, to the extent that he needs help, he can get better help and services outside of jail than he could inside.
Frankly, they shouldn't have to be here.
Right, and he agrees.
I mean, even if the prosecutor objected, they shouldn't have to be here.
Right. And Mr. Busick agrees. He's embarrassed and shamed by what he is putting, not only himself, but his family through in this. He's not proud to be here today, Your Honor.
When is this BCC set?
Thursday.
12.
So this Thursday.
Mm-hmm.
Well, I understand what the people's request, I understand what the defendant's request is. I don't think since he's gotten out until he's called to the carpet, this defendant really does conduct himself appropriately. I don't think that has anything to do with his parents or his family or his upbringing or anything like those lines. He just can't do it. And then starts sending, he's got an attorney. And he's just sending these emails to the court, accusing her of things. He's in her proximity. He doesn't need to be around her at all. He doesn't need to be contacted. And he just continued. And that's the part that is striking to me, is the allegations in this case was that he's arguing about some infidelity. He gets arrested. He goes to jail. He gets arraigned. And at no point after that whole process, after they told him, don't contact her, don't talk to her, he's got attorneys. He's all of those things. What does he do? He calls her again to berate on her. And it's very clear from her responses in the transcript. She doesn't want to talk to him about that. And he just keeps on. And then, if that isn't enough, he then says, oh, okay, well, just like paraphrasing, well, if you won't answer me, I'm going to try to get you in trouble and get you locked up. So I'm going to send this a month after. He's just playing games. And quite frankly, if he's playing games, he's playing with the wrong judge to play those games. Defendant's bond is going to be set, and the court is going to find on two bases. One, his violation after the bond terms were set, the court can review his bond. But I also think, given the way this defendant is exemplified by everything, that it was indeed an abuse of discretion to set his bond at a personal or cognizant bond in this case. Defendant's bond will be reset. The conditions still apply. His bond will be reset at $50,000 cash surety.
Would you consider a 10% provision, Judge?
cash surety. You can raise it again if you want to on the 12th, but right now he's going.
Watch this.
My question is, how
And
does it make sense, not make sense for me, but it makes sense from the attorney? You're
I'm
being
done.
biased.
I'm done. You're not
You're
gonna
biased.
interrupt me.
You're very biased.
You're not gonna keep interrupting me. Motion
Sorry, I was
denied.
never trying to interrupt you. You're
Motion
very
denied, writ
biased.
may issue. Thank
You're
you,
very
I'm done.
biased and disrespectful.
I'm done.
You're very biased, rude, and disrespectful.
Just mute her and kick her out of the meeting. Arbor Woods versus Kiera Morris. This is her motion to set aside default.
It is indeed. And we did file
I'm here, Judge. I'm sorry. I couldn't get my phone to work.
All right, that's her. Oh, there you are. Hello, state your name.
Here, Morris.
All right. This is your request to set aside the default.
Yes, sir.
All right. And what's the basis? You said you were unaware of the hearing?
No, so I was aware of the hearing. I was available for the first hearing. The attorney's office reached out to me and let me know that the staff needed to be trained and that they were looking to resolve. So I had to keep reaching out, and nobody reached out to try to come to a resolve. So when the court date did come up, I just couldn't get back in time because I am working a contract with veterans in Las Vegas right now. So that is the reason why that I could not make it. I do believe my Zoom hearing was denied. So that's why I need to file a motion to actually be here.
Okay. Have the funds been paid to the landlord?
So that was the situation for the court date. Just in agreement of what funds they're saying are owed is not accurate.
Okay. I took a judgment was taken in November for $1,571.06. You're saying you don't owe that amount?
Yes, sir. That judgment was the day that I was not there. So we were supposed to try to come to a resolve. The issue actually stemmed from May. And Rachel Dornbush, I did speak with her on the issue in May. She did try to correct some things that we did not come to an agreement. There was a court date scheduled for May 16th, but somehow that was dismissed. But even on the Arbor Woods paperwork, they still had down that I had a balance. So we still should have been in court. So that is, I guess they didn't communicate that with their attorney because this is like all the way from May. So this issue has never been taken care of.
Your Honor,
Yes.
I'm looking at the ledger, and the reason that the case was dismissed is because there was a balance. I mean, there was a credit. I mean, there was nothing due and owing. So the case was dismissed for that reason. Your Honor, first and foremost, I mean, I'm going to object to the motion even proceeding because none of that was stated in the motion. The motion says I was unaware of the hearing. If there was something more that needed to be addressed as a part of this motion, Ms. Moore should have included that in the motion instead of making a false statement alleging that she was unaware of the hearing. That is verbatim what her motion says. I was unaware of the hearing, and this was only filed beyond 10 days because of the holiday. Well, if she was aware of the hearing, then she could have filed her motion on November 19th, November 20th. She could have filed it long before the holiday occurred, which prevented her allegedly from getting to the court to do it. So I'm going to object, Your Honor, that this motion hearing even moves forward on that basis. And I am going to request actual attorney's fees because the motion that was filed is clearly erroneous and a false statement was made to the court.
I actually did file more than one motion. The motion that I did file for the Zoom hearing, it was actually denied. So I did have to file another motion. And I did speak with two representatives at the court. One of the girls' name was Ashley, and they did let me know that I did have that time Two, I actually sent a paper and I took a scan of it, and I sent that in with the explanation of what was going on with the case. So I think you may have read it incorrectly. I can pull it up and I can read it to you now. But the only reason why I was not there is because we were supposed to come to a resolve and no one ever reached out. And Rachel Dornbush, when you're speaking on it was a zero balance, if you check back onto your attorney's documents, onto your client's documents on the ledger, the same day that I spoke with you and you put that credit onto my account and we did not agree on my rental rate, they went back and put a non-sufficient funds fee there. So on the same day, there was definitely a balance and we should have been in court on the 16th. They didn't communicate that with you. My rent was supposed to go
First
up
of all,
in August. I'm sorry.
there was, so, and I'm just to try to get the order of this, and I don't know if you've got this, Ms. Dornbush, there was, so what I have is exactly what you stated on the motion. On her request for a Zoom hearing, she just had indicated that she's currently working out of the state of Las Vegas. I was hoping to come and resolve, but I have not received a call back yet. I can get a flight after work, but I'd be late for court. Please allow me to appear via Zoom. There's a 3-hour time difference.
And so I believe that was in the Zoom request, Your Honor, that was submitted to the court the day before the hearing on, I think, November 17th at around 3:30 p.m., which was after she contacted our office on the same day. She contacted our office around 3 p.m. and was reminded of the in-person bench trial scheduled for the 18th. But her motion that was filed with the court says, I was unaware of the hearing and it's only after 10 days because of the holiday. That is false. Ms.
It's
Lawrence was
absolutely not true,
100% aware of the hearing.
If we're speaking on things, I'm sorry, my phone blanked out. If that may have been, I did file 2 motions. So I don't know if both of them actually came through. I can't pull up the ones that I have and I can send it back into the court.
Ma'am,
So
I have your signature on a motion to set aside the default. And under paragraph 2, you're asking the court to set aside the judgment. And it indicates that it must be filed within 10 days of the default judgment. And then it's because, and you wrote in, I was unaware of the hearing, and it's only after 10 days because of the holiday. The first part of that is it's patently false. You were aware of the hearing because you filed the request for a Zoom on that, so you knew the hearing was taking place. And then you said it's after 10 days because of the holiday. I don't even get that because the judgment was on November 18th, and there's at least really 7 days, well, more than 7 days before the holiday. There was like 9 days before the holiday that you could have filed it. So,
I'm confused on the motion.
It did not get filed with us until December 1st was your signature, and that's when our timestamp is.
And yes, I do. I'm not trying to cut you off. I did call in. She did let me know that I had a few more days, and she let me know that I had to file a motion. I have the emails from you guys, and I never got the $20, I guess the check thing to actually put the motion in online. So I had to have someone come up there and do it. I would have had the motion in prior to that. My Zoom hearing was denied, and I did submit a piece of paper with a lengthy information on what we're talking about. This is the same conversation that we had prior to when the other attorney decided that they needed to train staff and we're trying to come to a resolve. So my information hasn't changed and my issue hasn't changed either. And if we would have been in court in May, because that ledger says I had a balance.
Ma'am, trying to go back to May, Ms. Dornbush just stated you had a credit on your account and that's why they dismissed it.
Correct, the same
So-
day, Judge. Ms. Dornbush is not
But-
acknowledging that her client put a non-sufficient funds fee and reversed that payment back onto my ledger after I spoke with her.
When are you saying that happened?
That happened on the same day on 5/6 of 2025.
Do you see that on the account, Ms. Dornbush?
I do see that, Your Honor, and I believe, I can't speak to it with certainty because I was unaware of that until Ms. Morris brought that up. But if a dismissal had already been submitted to the court, my client would have then had to motion the court to reinstate the case, number one, to try to pursue those amounts. And following that, Ms. Morris did continue to make payments on the account in June. Payments were made and credits were done to the account, leaving a balance of $50.49. And so I don't believe my client felt there was a reason to reinstate based on subsequent payments being made.
Well, sorry, I don't want to cut you off. Just to let you know, Ms. Dornbush, because I know you didn't speak to your client. I spoke to them and we were going back and forth. They ignored my phone calls, a whole lot of things. That was done probably about 2 hours after me and you had spoke. And they literally have it on the ledger. They knew about it and it took over 30 days for them to actually correct that. And they also put a $30 late fee onto May's rent as well. So this is an issue that needed to be addressed because just like with the $2, my rent was supposed to go up in August. That's the whole 12 months. So I understand that you
What is her
didn't.
current balance?
The current balance, Your Honor, hold on. I've got to find the current ledger that I have for this case. Give me just one moment. With December, Your Honor, $2,364.19.
And ma'am, if I take everything that you're saying, how much are you saying you owe?
Honestly, Judge, there was a discrepancy in.
I know
September.
that.
Okay,
So
I'm saying in
you tell
September.
me,
Yeah.
taking out all of that,
Mhm.
how much do you think you owe right now?
I think I owe them around $300 from the discrepancy that the office made in September, sending out a notice, 7-day notice, saying that my rent was $360.
Did you pay December rent?
Yes, I did. I paid it into escrow at the court, and I did that with November's rent as
Okay,
well.
I've got 700. So you're saying that if I take that 700 off, add the 300, so basically $1,000, that you're saying that there's an error on your account in the amount of $1,364.19.
Yes, it is.
Absolutely not, Your Honor.
You can say absolutely not.
Where
If you
is
look at
that
the
going to
first.
come from, ma'am?
So where it's coming from is my lease is supposed to start in August. They charged me a lease increase in May, June, and July. My lease is supposed to be from 8/1/2024 to.
All right, so in May, June, and July, what are you saying they charged?
They charged me $694 for lot rent.
And if you're saying that, what should it have been?
My lot rent should have been $657.
So that's about a $50 difference each of those months. That's $150.
On top of late fees.
So how many late fees?
They charge you 2 late fees per month.
Okay, so
that's
even if they
$85
did
per
that,
month.
and Ms. Dornbush, maximum amount of late fees per month is what?
Your Honor, the late fees total per month is $55 that gets charged on after the 5th and $30 that gets charged on the 21st. So it's $85 a month. However, let me go look at Ms. Morris's ledger and see if she's actually making these payments timely. Because if she's not making her payments timely, whether there's a discrepancy or not, the late fee would have hit. So
I hear you on that. But what I'm getting at is your numbers aren't matching, because even if I take 85, give me 85 times 3, give me 85 times 4.
5 times 4, 340.
340. So I've got 150 and 340. Where else are you claiming that there's a discrepancy of some type?
Okay, so moving forward, if you look at to July, well, you took that. If you said my rent was $657 in July, I went into the office. They locked my mailbox, and I have been kicked out of the customer portal to pay online. So I get charged a $10 fee with every payment.
Ma'am, listen
If
to
you
me.
look on, if you look on my
Listen
ledger,
to me. You are claiming that there is some $1,300, almost $1,400. That is a discrepancy on your account. I'm
Yes,
asking
sir.
you for where that discrepancy is.
Okay,
You
sir,
are
and
giving me
I'm
150. I'm not
sir.
agreeing with you. I'm just saying,
Mhm.
where are you getting these numbers?
So where I'm getting these numbers from are my ledger. It started in May. So they put a non-sufficient funds fee on the account. After they put that non-sufficient funds fee, they added that money that was owed for May, the rent, they added that onto June. I have a 7-day notice from June. It says my rent at the top of the paper is $657, but they're not putting that onto the ledger. So that isn't carrying a balance. They put the non-sufficient funds fee, put the 718 back onto my ledger around June 12th or June 13th. Moving forward, we still had a balance in July. No one is trying to come to an agreement about the balance with my ledger. So it kept on incurring. Then we get to August. I go into the office. They say I owe $175. So she says, well, you know what? Since you've been locked out of your account, her name is Dana. She said, you've been locked out of your account. We'll credit you those $10 fees back. I'll do 17 of them. We're going to investigate. We'll do more. Kenya just took those $170 credits off in October. Those were supposed to be taken off in August. I paid my October rent to the office. They told the court that they didn't have any rent. If you look at 9/6 on my 7-day notice, Kenya, the new manager, sent out she sent out a letter saying I owe $360.
Ma'am, you are telling me that there's some $1,300, $1,400. You are not telling me where those numbers are coming from. You
Okay,
have
so let me
given
rephrase
me
this,
a
Judge.
total amount of $490, basically, that you're saying shouldn't be on your account.
I said there's a total, the $450, if you look at my ledger that I paid in September, that was supposed to be the total balance owing for September. That was a staff error. It was $360. I made a $450 payment to cover the late fees. So I should not have a balance. That was a staff error, not my fault. They sent me one paper in the mail and they sent another paper to the court. They also tried to steal my money order. I also submitted to the court the payments that are made on their check system. My money order from May is not in that check system. Kenya, the manager, asked me, well, did they actually put it back into the check system? I said, I don't know. So I asked her, could I have proof? So all of this, my account is screwed up since May because of these different charges. They're saying I owe $2,000, but they also charged me a late fee and my rent was in escrow in November. My rent was paid to the office. The only time my rent was short was in September of 2025. And that was a staff office error. That was not a tenant error. I paid what they said was owed. Then they turn around the same day and send the court the same paper with different numbers on it. That's not my fault. All of their information that they even sent into the court with my lot rent. Sometimes it's $266, sometimes it's $391. And Rachel Dornbus, you or the rest of your colleagues never addresses it. They started my lease last year in 2024 in July. It was supposed to start in August.
Ma'am, here's the problem. Problem is, your motion says none of this.
Is that my motion, a motion that I did, or did someone else do that?
I don't know.
Because I can send it back in. I can send proof back in.
Ma'am, you know, if you keep interrupting me, because I'm about done. You're not answering my question. You're not giving me the figures. You gave me some figures which amount to 490, but that doesn't even make any sense to me.
Okay. My question is, how does it not make sense for me, but it makes sense from the attorney? You're being biased.
I'm done. You're not going to interrupt me.
You're very biased.
You're not going to keep interrupting me. Motion
Sorry, I was never
denied.
trying to interrupt you.
Motion
You're very
denied, writ
biased.
may issue. Thank
You're
you,
very
I'm done.
biased and disrespectful.
I'm done.
It doesn't matter. You're disrespectful and
am
you're very
done.
biased. You need to do your job.
I
You don't know
am
how to do your
done.
job. That's
Mute
all.
her. I am done. Motion denied.
Your Honor, I would request that the money is held in escrow. I think, Your Honor.
The monies held in escrow are released to plaintiff and will be applied to the account balance.
Thank you, Your Honor.
You have an attorney, you have a boss as well. You're very biased, rude, and disrespectful.
Mute her and kick her out of the meeting. Court does call the case of Arbor Woods versus Lakeisha Sanders.
Yeah, that has having receipts very important. Very, very important. You know what, ladies and gentlemen, I'm calling this one a day. It's been an interesting week this week. Yes, the live scanner feed will be tonight. And then when I get up in the morning, stop the feed, I'm going to lay my ass back in that bed and sleep. There will be no court stream tomorrow. Sunday will be body cam footage, and then Monday we return back to our judges' dockets. So, you all have a wonderful evening. Ta-ta and ciao-ciao. I will see you on Sunday for our body cam footage. I'm taking the day off. You all behave yourselves if you can. And I will catch you on the next live stream. You guys are so wonderful. You all have a wonderful, wonderful, wonderful 4th of July. And be safe, everybody.
Everything's okay.